Cannabis and appellate law practices collaborate to prepare amicus brief to U.S. Supreme Court in challenge to marijuana schedule. The National Cannabis Industry Association (NCIA), the largest cannabis trade association in the United States, and the ArcView Group, the cannabis industry's oldest and largest investors network, stepped forward as amici before the U.S. Supreme Court in the case of Marvin Washington, petitioner William P. Barr, and etc., which seeks to invalidate marijuana schedule status under the Controlled Substance Act (CSA) on contextual grounds. Both organizations have a significant interest in the responsible and legal development of a sustainable cannabis industry in the United States, as well as in protecting the constitutional right of their member constituent, patient, and consumer. Wilson Elser's Cannabis Law and Appellate Practice team drafted their amicus brief for a writ of certiorari in challenge to marijuana schedule status. The petitioner include two children with serious seizure disorder who require life-saving medical cannabis, an Iraq War veteran who treats his severe PTSD with medical cannabis, and a former NFL football player who is now an entrepreneur in the medical cannabis space. In their complaint, filed in the Southern District of New York, the petitioner asked the trial court to strike down marijuana schedule status on the basis that it violates their right under the Due Process Clause of the Fifth Amendment of the United States Constitution. Both the trial court and the Second Circuit Court of Appeals held that the petitioner were required to exhaust administrative remedies with the Drug Enforcement Administration (DEA) before they could seek a legal remedy with the court. The petitioner then appealed to the United States Supreme Court. The NCIA and ArcView joined the petitioner's argument that the lower court erred in requiring exhaustion of administrative remedies, which would result in the petitioner facing substantial prejudice because the DEA maintained an irrational and archaic position on the scheduling of cannabis that is out of step with sweeping medical, scientific, legal, and social advance. The amicus brief argues that the DEA isn't only unwilling but also incapable of providing the remedy sought by the petitioner, making exhaustion futile and inappropriate. As recently as 2016, the DEA reiterated its long-standing but flawed position that it cannot legally classify cannabis anywhere but Schedule 1 of the CSA or potentially Schedule 2 due to the international treaty obligation. Reclassification of cannabis to Schedule 2, however, doesn't represent a viable remedy for the petitioner. The DEA had multiple opportunities since the early 1970s to determine the proper classification for cannabis under the CSA, including whether it should have any classification under the stated. The evidence nevertheless led to the inescapable conclusion that the agency has for decades consistently devalued or ignored advances in cannabinoid science. Indeed, the Second Circuit acknowledged in its decision under appeal that based on our current state of knowledge, it is possible that the current law, through rational one, is now heading toward irrationality. It may even conceivably that the has gotten there already. This is precisely the point. The DEA can reasonably be expected to determine whether its own intrinsic position has become so irrational that it now violates the petitioner's constitutional right. That is an issue squarely within the domain of the court, not a federal law enforcement agency. In dismissing the petitioner's constitutional claim, the Second Circuit casually concluded that it cannot be seriously argued that the reclassification or descheduling cannabis isn't available through the administrative process. Yet petitioner make precisely this argument. In our amicus brief, we further ask the Supreme Court to consider whether it is reasonable to believe that filing yet another petition with the DEA would cause the agency to reverse an entrenched legal position that has become irrational over time, and particularly when the agency was vigorously defended that position since as long ago as 17 and as recently as 2016. Thank you.